I would like to start with a quick outline of today's presentation, which is divided into three parts. The first one puts the spotlight on Article 80 of the General Data Protection Regulation, GDPR by its acronym, which is the building block of collective enforcement of data protection rights. That provision is a newcomer, as its predecessor, the Directive 95/46 on data protection, contained no equivalent. Basically, Article 80 GDPR allows certain bodies, organizations, or associations to exercise several rights on behalf of data subjects. I will refer to those as entities for the sake of this presentation, as it is handier. As we will see in a minute, those entities must fulfill several conditions in order to be able to represent data subjects, irrespective of the mode of representation. There are basically two modes of representation, which are embedded in the different paragraphs of Article 80, the representation with mandate or without it. Although the analysis focuses on Article 80 GDPR, we will soon have to deal with the presence of another piece of legislation dealing with collective redress in the data protection field, that is the Directive on Representative Actions. Since it was the object of the previous presentation, I will only make punctual references to it. Then I will present three recent examples of collective enforcement claims. Because of time constraints, I will not talk about complaints brought to supervisory authorities. The reason is that judicial actions make mismatches between Article 80 GDPR and national collective redress schemes more visible. Finally, the third part of this presentation will be dedicated to conclusions. Before we further analyze the content of Article 80 GDPR, there are two contextual elements that you're invited to keep in mind as they impact that provision and make its interpretation more complex. First, although the GDPR is a regulation in nature, it is a general one. Accordingly, more than 50 open clauses were drafted so that member states were given some room for maneuver in the implementation of the regulation. As we will see, Article 80 contains two of those open clauses. Moreover, the enforcement of both individual and collective claims can only work with the enactment of efficient procedural tools at the national level. In other words, the GDPR cannot work alone. As far as private enforcement is concerned, we need a way to vehicle those claims. Second, at certain point in this presentation, you will be able to sense the presence of two opposing policy considerations that may influence the interpretation of Article 80 GDPR. Those policies drove the implementation of collective redress in the EU, and quite naturally, they are visible in Article 80 GDPR as well. On the one hand, the idea is that the adoption of collective redress strengthens access to justice, but on the other hand, it is necessary to limit its use in order to avoid abusive litigation. We will see more precisely how those concerns materialize later in this presentation. As I announced in the previous slide, Article 80 enables representative entities to litigate on behalf of data subjects following certain modes of representation described in paragraphs 1 and 2. Therefore, that provision refers to a specific collective redress model whereby data subjects do not directly litigate their interests themselves, but entrust an intermediary to do so. I think we can fairly say that it is the most widespread collective redress model adopted in Europe so far. This necessarily excludes alternative collective redress schemes, such as the English group litigation order, which involve no intermediaries. Basically, the GLO system creates a register where victims opt in, but no representation mechanism is triggered, and hence all claimants are parties to the proceedings. In my opinion, it does not mean that those collective redress schemes cannot be used in the data protection field. Indeed, Article 80 GDPR only regulates a collective redress model whereby the data subject is represented and hence has less control over his or her claim as he or she does in individual litigation. In that case, the regulation offers a legal framework which ensures that the data subject is correctly represented. In my view, Article 80 does not cover schemes where the data subject is in full control of his or her claim. Therefore, those models should remain at the disposal of victims of data protection violations. So here is the text of Article 80, which specifies the conditions that entities must fulfill in order to be able to represent data subjects, which I highlighted in green on the slide. First of all, entities must be not for profit. The objective behind this requirement is to impede the creation of a litigation culture with the rise of greedy special purpose vehicles. Here, the policy against abusive litigation, which I mentioned a few minutes ago, is quite visible. This means that entities such as cartel damage claims, for example, dedicated to the enforcement of victims' rights in the competition law sector, do not fulfill that requirement. Second, the entity must be properly constituted in accordance with the law of a member state. Such terminology is rather generous, as the existence of a given entity does not depend on the law of a specific member state. Rather, an entity will be able to benefit from Article 80 GDPR if it is properly constituted according to the law of any member state. Third, representative entities must have statutory objectives in the public interest. This choice of words is a little unfortunate, I think, and I think that we should understand it as a reference to bylaws or articles of association. Be it as it may, I believe that the introduction of such a requirement limits standing to persons with a legal personality, as opposed to individuals, such as Mr. Schrems, for example. It is also unclear to me whether public bodies, such as Consumer Ombudsman, will qualify under Article 80 GDPR. Note that the Directive on Representative Actions is clear in that regard, as Professor Wood mentioned, as public bodies are specifically included in the notion of qualified entities. Finally, in order to be able to bring representative actions, entities will have to demonstrate that they are active in the field of data protection, of protection of data subjects' rights and freedoms. Here, I guess that courts will have some discretion in examining that point. For example, an organization such as None of Your Business would fulfill that requirement by showing that they regularly campaign for the respect of data protection rights, they present complaints to supervisory authorities, and they already have some experience in bringing claims to courts. Article 80 GDPR is composed of two paragraphs modeling the exercise of the representative action. On the one hand, Article 80, paragraph 1 allows representative entities to exercise the right to lodge a complaint with the supervisory authority according to Article 77, and the right to effective judicial remedy against a supervisory authority, a controller, or a processor embedded in Articles 78 and 79. On top of that, and where member state law provides for it, entities will be able to exercise the right to compensation in accordance with Article 82. Here is our first open clause. Most importantly, perhaps the representative entity must receive a mandate from data subjects in order to exercise those rights. At first glance, one could think that the object of this paragraph simply covers collective redress mechanisms having an opt-in structure. But the different procedural tools adopted by member states show that not all opt-in-based mechanisms require representative entities to be previously authorized by data subjects. For example, in France, in case a consumer association brings a group action, French courts will rule on the liability of the defendant first. Only then will the judgment be notified to the group of affected victims who will be able to opt in or not. So the notion of mandate is rather unclear and unfortunate when talking about collective redress. Moreover, it seems to me that Article 80, Paragraph 1 excludes actions that protect general interests. By general interests, I mean those which concern a group of people at large and for which no individualization is possible. Typically, actions that aim at protecting the environment against polluters or the market against unfair terms concern a general interest. I think that Article 80, Paragraph 1 only covers collective interests understood as a group of homogeneous individual claims, as the wording of this provision makes clear that representative actions must be brought on behalf of data subjects. Nevertheless, actions for the protection of general interests are covered by the future Directive on representative actions, which applies to the data protection field. This poses the question of the interaction between Article 80 GDPR and the Directive. Does Article 80 GDPR build up an exclusive procedural system for the collective enforcement of data protection rights, or can the Directive offer a parallel regime for actions which are not contemplated by the GDPR? This is precisely the question that the German court recently referred to the Court of Justice. The case involves an action for injunctive relief started by a consumer association against Facebook for breaches of the GDPR. Specifically, the association criticizes how Facebook transferred the personal data of users of the App Center, offering online games for free. It considers that the clause enabling that transfer, which pops up on user screen as they open the games, was not precise and clear enough for data subjects to effectively give informed consent. Since the action for injunctive relief aims at protecting the general interests of data subjects, the German Supreme Court referred the case to the Court of Justice for preliminary ruling. It essentially asks whether that type of action is allowed in parallel to Article 80 GDPR or whether the latter prevents them. I personally believe that actions which are not covered by Article 80 GDPR, for example, actions protecting general interests or brought under a non-representative mechanism such as the English GLO, have to be allowed. Another conclusion would both contradict the Directive on Representative Actions, the text of which authorizes those collective redress actions, and to severely restrict access to justice. So here is the text of the German Supreme Court's question in original language, if in case you want to have a look at it after the presentation. So back to Article 80 and its paragraph 2, which is entirely dispositive. You can see that the text of the paragraph starts with member states may provide, a choice of words which makes clear that the whole paragraph is an open clause. According to Article 80, Paragraph 2, member states may allow entities to exercise certain rights without any previous mandate. This typically includes collective actions based on an opt-out system. Most importantly, the right to compensation is in any case excluded if no previous mandate is given by data subjects. This result is, in my opinion, very unfortunate since several member states have already adopted rules allowing actions for damages without any authorization being necessary. I consider that the limitation introduced by Article 80, Paragraph 2 decreases private enforcement. Again, I believe that the protection of general interest is excluded from that paragraph since the presence of individual victims is required. The open clauses of Article 80 GDPR require member states to make procedural choices and implement them into their legal order. Also, because private enforcement depends on the existence of efficient procedural tools, national laws on civil procedure need to back up Article 80 GDPR. As I will show you in a minute, the procedural tools crafted by member states often depart from the text of the GDPR, and this is quite natural since many of them have been adopted before the entry into force of Article 80. Even though national laws must comply with Article 80 GDPR, I believe that this provision could have looked a little more at member states' procedural laws in order to reduce inconsistencies. The research that I carried out regarding the implementation of Article 80 GDPR shows that national laws are sometimes more permissive than the wording of that provision. Two examples are given on the slide. First, the Dutch Mass Damage in Collective Action Settlement Act, which entered into force in January this year, enables representative entities to bring collective actions for damages on an opt-out basis. This runs against the wording of Article 80, paragraph 2, which excludes the right to compensation when no authorization is given to the representative entity. Second, the Spanish collective redress system that is embedded in the law on civil procedure enables a group of victims to represent the class. However, under Article 80 GDPR, standing to sue is limited to representative entities as opposed to individuals. I also discovered that several national laws impose more stringent conditions than Article 80 GDPR. For example, the French law governing group actions contains stricter requirements regarding standing to sue. Accordingly, representative entities must have a certain size and years of existence in order to start a group action, but these requirements are not mentioned in Article 80 GDPR at all. Also, in Belgium, a collective action may be brought in case of infringement of the law on data protection. Nevertheless, the personal scope of that action is limited to consumers, meaning natural persons who act for purposes that do not fall within the scope of a commercial activity. And this is unclear whether that notion can simply be replaced by the slightly broader concept of data subject when data protection violations are at stake. So the mismatches between national procedural laws and Article 80 GDPR poses the question of how much leeway is actually left to member states. In other words, does Article 80 allow member states to depart from its wording, and if yes, how much? There are two possible interpretations. On the one hand, because the GDPR is a general regulation, one could argue that where no open clause exists, member states shall not be allowed to depart from the text of Article 80 GDPR. The more stringent conditions on standing to sue, for example, but also a more generous wording would not be acceptable under that approach. On the other hand, we saw that the nature of the GDPR isn't clear and that the presence of open clauses suggests that the regulation is not hermetic. Along that line of reasoning, when national law goes further than the regulation but does not contradict it, one could consider that it should be applied. Conversely, where national law imposes stricter conditions which clash with the regulation, these should be discarded. The problem that I see with the second interpretation is that two opposed policy objectives play against each other here. As I mentioned earlier, they underlie the adoption of collective redress in the EU since the very beginning and are visible in Article GDPR as well. Let us take the example of standing to sue. On the one hand, private enforcement suggests that more generous conditions on standing should be acceptable, as it means that more categories of people could defend their rights collectively. On the other hand, however, the desire to limit abusive litigation would command to restrict standing to a limited representative group of people. That example shows how difficult it is to evaluate what goes against the regulation and what goes with the flow. So we now turn to the second part of this presentation, in which 3 recent examples of collective actions will be presented. We start with the Lloyd versus Google case, which takes place in the UK. Richard Lloyd is a started representative action under Rule 19, paragraph 6 of Civil Procedural Rules on behalf of similarly situated data subject against Google. He argues that Google infringed the Data Protection Act of '98 by tracking the personal data of millions of iPhone users using the Safari workaround and subsequently sold that information to advertisers. Even though the case is pleaded under the old regime of the Data Protection Act, the interpretation of courts will likely be valid for the Data Protection Act of 2018 as well as the GDPR. Under Rule 19, paragraph 6, an action can be brought by a representative of a group of persons having the same interest in the claim. In principle, the representative action is based on the automatic membership system, but the literature admits that represented persons may apply to be excluded from the class. At the end of the day, this is equivalent to an opt-out based mechanism. I observe at least 2 inconsistencies between the representative action of Rule 19 and Article 80 GDPR. First, the English system of representative action enables an individual to act on behalf of a group of data subjects. On the contrary, as I highlighted earlier, Article 80 GDPR limits standing to representative legal persons. Second, the representative claimant can start proceedings without obtaining a previous mandate from similarly situated victims. Now, one could think that Brexit will soon make those mismatches irrelevant. After the end of the transition period, the UK will have no obligation to adapt Article 80 GDPR into its legal order. Nevertheless, the Data Protection Act of 2018, which will remain in force after the transition period, maintains some confusion. To be more specific, its Section 187, paragraph 1, authorizes a body or other organization which are sufficiently representative to exercise several rights on behalf of data subjects if they are instructed to do so. Therefore, this section looks quite a lot like Article 80 GDPR. The problem is that the existing procedural tools in the UK have not been modified to comply with that section, and so there is now a mismatch between the Data Protection Act and the Civil Procedural Rules. The judgment of the Court of Appeal clarified an interesting point as far as the representative action is concerned. In the past, the same interest requirement imposed by Rule 19, paragraph 6 was narrowly interpreted. The Court of Appeal broadened the interpretation of that requirement by ruling that the members of the group were similarly situated in the case object of analysis. Specifically, the judge acknowledged that the represented class were victims of the same alleged wrong and had all sustained the same loss of control over data. It remains to be seen whether such an interpretation will stand, as Google appealed that judgment. Our second example is also a representative action, which was brought against Google in the UK last summer. The action is the first one in Europe that represents kids and their parents. To be more specific, the claim is brought by the father of 3 children under 13 years old, whose data has been unlawfully harvested by Google through its YouTube platform. He argues that YouTube infringed UK and EU data protection laws by unlawfully targeting about 5 million underage viewers with addictive programming and subsequently sold their data to advertisers. Nevertheless, both data protection laws impose stricter conditions on consent when children under 13 years old are involved. The father is is the representative claimant of those kids and their parents who are located in the UK. As I mentioned earlier, it is doubtful that the English representative action is compatible with Article 80 GDPR. There will be another opportunity for courts to interpret that procedural instrument and make the representative action either more accessible to victims or more complicated to use. Only time will tell. The last case involves a suit brought by a foundation called the Privacy Collective with a seat in the Netherlands against Oracle and Salesforce, two giant computer technology corporations which are located in the US. The foundation argues that the defendants unlawfully obtained personal data from internet users through third-party cookies, which they auctioned off to other companies without users' knowledge. The foundation argues that this practice violates the GDPR as data subjects did not consent to it. The Privacy Collective is allowed to start proceedings thanks to the recent entry into force of the Dutch Mass Damage in Collective Action Settlement Act. That act enables a representative entity to start compensatory collective action on an opt-out basis. In the case object of analysis, the foundation only represents Dutch internet users. As I highlighted earlier, it is doubtful that the Dutch Act is compatible with Article 80, Paragraph 2 GDPR, as it enables entities to seek compensation without data subject's mandate. Be it as it may, it will be interesting to see if the mismatch between Article 80 and this Dutch procedural rule will be raised as a counter-argument by the defense and eventually examined by the judge. The research carried out in the context of this presentation enabled me to elaborate 4 concluding points. First, I note that Article 80 GDPR has not had a major impact on the procedural architecture of national collective redress schemes. In other words, member states which already had a collective redress mechanism within their legal order did not bother to adapt it to Article 80 GDPR. They simply opened up their mechanism to the data protection field. Second, I must admit that I am quite disappointed about Article 80, Paragraph 2 GDPR, which limits the right to obtain compensation when the data subjects did not authorize the representative entity to do so. Since several member states already had a collective redress instrument allowing for such a possibility at the time the GDPR was drafted, I am not sure to understand the need for such constraint, especially because no abusive litigation that would justify such a policy choice has been recorded. My third point is that the overlap between Article 80 GDPR and the Directive on Representative Actions creates an unnecessarily complex legal landscape. Be it as it may, I believe that it is reasonable to accept that all actions falling outside the scope of Article 80 GDPR, for example, actions protecting a general interest or actions brought under non-representative collective redress models, should be allowed, as long as they are aligned with the Directive on Representative Actions. Finally, and in order to end this presentation on a more positive note, the major breakthrough of Article 80 GDPR was to unlock the collective redress system for data protection infringements. The 3 examples of actions prove that access to justice for the defense of data protection rights is broadening, and I personally take that as good news. This is the end of this presentation. Thank you very much for your attention, and please do not hesitate to contact me if you have any question or comments even after this presentation. Thank you very much.